Good afternoon, everyone. I'm Neil. I'm an internet lawyer. I'm the managing director of law firm Decoded Legal, and you'll be absolutely delighted that you're not going to hear my voice for most of this. 66 of you have signed up, which is absolutely fantastic. For those of you who've been to SCL events before, welcome back. And for those of you who are joining us for the first time, you're very welcome. We're delighted to have you here. A particular welcome to those of you who are students, as I know we've got quite a number of you today. We're really delighted that you're joining us this afternoon, given all the great student afternoon TV that would be taking up your time if you weren't attending a webinar about legal issues. And I'm particularly pleased that you're here because, as you will hear from Jess herself, Jess is also a student, and we'll really be delighted to hear an expert student's perspective on a particularly key issue. I say this afternoon, it's just gone 8 o'clock in the morning where Jess is. The internet is great at traversing national borders, but still sucks at dealing with time zones. So bright and early before Jess's first coffee of the day, I think. For those of you who are not members of the SCL Society for Computers and Law is an educational charity. I'm biased, but it's absolutely fantastic. I've been a member for many, many years now. If you enjoy this webinar, there is a huge amount of other fantastic content available through the Society. You can join at scl.org. We are recording the audio and video streams of this session so that people who can't enjoy it now will have the opportunity to do so in the future, or so that you can listen again. If you want to ask questions, please use the chat tool. If you want to do that anonymously, that is absolutely fine. Jess and I will keep an eye on the questions and try and weave them into the conversation, but there'll also be time at the end specifically for Q&A, so feel free to keep your questions until nearer the end and send them through. This webinar is made available free of charge. If you've enjoyed it and you'd like to donate to the SCL to help do more student programs in the future, you're very welcome to do so. Simon's going to drop a link into the chat. It's buymeacoffee.com/SCL, but it's not going towards coffee. It's going towards the SCL's student programs. But enough about the SCL. Our speaker today, Jess Miers. If you are a user of Twitter, Jess is on there, and Jess is pretty active on Twitter. She is at Jess_Miers. She's not on Mastodon yet, but no one's perfect. Important point to note. Jess has recently started work at a small internet company that you might have heard of called Google. If you haven't heard of it, I'm sure there's an online search tool which you'll be able to use to find your way there. The key point is that what you're going to hear are Jess's views and Jess's views alone. They're not the views of Google or any of the other organizations that Jess has worked for or with which she's affiliated. Jess and I share a passion for the internet, but Jess has taken it one step further, and she's actually got a tattoo of her favourite law, Section 230, on her wrist. Getting this done was a pretty painful experience, and I'm just relieved that Jess's favourite law is Section 230, and not the investigatory powers interception by businesses for monitoring and record-keeping purposes regulations 2018, but there we go. You'll also see she's got a little squiggly sign at the front of 230 on her wrist. So for any EU lawyers wondering why someone would use that key on the keyboard, that's how you do it. Although we found out European keyboards have that funny US section squiggle on the keyboard. US keyboards apparently don't have it. So there you go. Today's talk, so excited about this. Jess is going to talk to us about her favourite law, Section 230. And in particular about content moderation. She's going to talk about how this law, for which the European approximation is Article 14 of the E-Commerce Directive 2031 EC, how it empowers online platforms and enables them to moderate rather than prevents or discourages them from doing so. Jess is also going to talk about issues of platform neutrality, of editorial expression, of publisher or platform, a whole lot more. And as I say, there is going to be plenty of time for questions at the end. So I promised you wouldn't hear much from me today. With that, I am absolutely delighted to hand over to our speaker for this afternoon, Jess Miers.
Hey everyone, thank you so much for joining. I'm honored as a law student. This is actually really cool. Neil, that was a fantastic introduction. Thank you as well. Section 230 is something that I am super passionate about. I just kind of like some quick background. I'm a computer science undergrad. I decided to go into law because I learned very quickly that I suck at coding and I wasn't super passionate about it, but I really loved talking about technology. I did a deep dive into what is out there with regard to technology law. Discovered Professor Eric Goldman's blog while I was taking an internet law class during my undergrad year, and just sort of fell in love with Section 230. I've always been a huge free speech nerd, always been a huge proponent of the internet. I started on the internet very young, so this was kind of this blended everything that I was interested and passionate about, and I kind of just took off from there and decided the summer before I start law school, I'm going to learn absolutely everything that I can learn about this law. And as Neil said, I am very active on Twitter, so if you do follow me, I warn you, I pretty much only tweet and talk about Section 230 and content moderation, and occasionally law school. But anyways, thank you so much again for joining. I'm super excited to have this conversation. I'm just going to do an overview of Section 230, and then, as Neil said, we can do kind of a more casual conversational back and forth with questions. So with that, I'm going to go ahead and share my screen. So yeah, like I said, this is going to be an overview of Section 230 and content moderation. Super excited to kind of dive into this with you guys. Just kind of a quick about me. So I'm Jess Miers, and if you can't tell, I am absolutely passionate about the internet and Section 230 from these pictures, and online free speech. So like I said, currently I'm a third-year law student at Santa Clara University School of Law, where I study internet law and policy. And at Santa Clara Law, I'm super privileged to be a research assistant to the renowned Section 230 expert and thought leader, Professor Eric Goldman. This summer, I'm also a research associate at UCLA Law, where I'm currently writing a law review article about the intersection of the right of publicity and Section 230. And before that, I was a legal intern at Twitter and Tech Freedom, a DC technology policy think tank. As of current, I am a full-time legal policy specialist at Google. I just started about a month ago, and I've been loving every minute of it. As many of you have probably guessed by now, my research and scholarship primarily focus on Section 230 and content moderation, and I've spoken and written extensively on both topics. You can find my CV on my blog at controlaltdissent.com. So before we dive into this presentation, I thought we might start with the seminal case on Section 230. This is the Ken Zoran v. America Online case. You may have actually heard of it. This is kind of the case that most internet law classes actually start with. So the bombing of a federal building in Oklahoma City tragically shook the nation on April 19th, 1995. This horrific act of domestic terrorism claimed the lives of about 168 people, including 19 children, and injured hundreds more. Just 6 days after the bombing, AOL user KenZZ03 posted an appalling message to the Michigan Military Movement message board. T-shirts and merchandise emblazoned with slogans such as "Visit Oklahoma, it's a blast," and "Putting the Kids to Bed, Oklahoma 1995," and "McVeigh for President 1996 were available for purchase. You just had to, quote, call Ken. The post included Ken Zoran's actual phone number, baiting abuse from understandably distressed AOL users. As one can imagine, what followed were death threats and harassment. Zoran immediately called AOL to get the post removed, but the company delayed. Only after the damage was done and Zoran was permanently and emotionally scarred and his business and reputation were ruined, did AOL finally remove the posts. Zoran sued AOL for negligence. In a powerful decision, the Fourth Circuit declared that AOL was immune under Section 230, a law that broadly protects internet providers and users. What seems like a tragic loss for Ken Zoran was actually the most important judicial decision for the internet to this date. And we'll explore why that is. So just a really quick overview of what we're going to be talking about. I'm going to talk a little bit about Section 230's legislative history because it's interesting. Then we're going to get into like creating a new liability framework for the internet, how Section 230 did that. Talk a little bit about why Section 230 is known as the law that created the internet. We'll get into a little bit of content moderation and explore the Moderators Dilemma. Talk about how Section 230 is the sword and the shield when it comes to content moderation. We'll talk a bit about what Section 230 does, and importantly, what it doesn't protect. And lastly, we'll talk very briefly about Section 230's uncertain future in the United States and some of the proposed regulations leading up to it. Okay, so you've likely heard the phrase Section 230 of the Communications Decency Act, or CDA 230. Personally, I cringe whenever I hear either version. Indeed, CDA 230 is actually a very ironic misnomer. The Communications Decency Act was a federal regulatory amendment to the Telecommunications Act of 1996. It was proposed by a little-known senator from Nebraska named James Exon. The problems posed by the early 90s internet were strikingly different from the problems we encounter today. While today we're worried about mis and disinformation, sex trafficking, viewpoint bias, election interference, Russian hackers, trolls and bots, and dangerous conspiracy theories and miracle cures about COVID-19, the users of the early World Wide Web were concerned about pornography. Exxon and his constituents were especially concerned about children having easier access to indecent materials. The Communications Decency Act was essentially designed to curtail the fruition of the internet pornography, which we consider constitutionally protected speech. From users to internet providers, the CDA charged the federal government with the task of fining and imprisoning anyone that was caught posting or hosting such material. The CDA amendment to the Telecommunications Act was passed by the Senate. Meanwhile, House Representatives Ron Wyden and Chris Cox were working on their own amendment to the Telecommunications Act as well under a bill entitled Internet Freedom and Family Empowerment. As technology mavens, Cox and Wyden feared the chilling effects the CDA presented for the burgeoning web. Hence, their amendment aimed to remove the burden of liability from internet companies with the hope that this would empower internet companies to become good Samaritans of the web. The Wyden-Cox Amendment also passed. Shortly after, President Clinton signed the final version of the Telecommunications Act into law, which included both the CDA and the Wyden-Cox Amendment. Almost immediately, the Supreme Court struck down the CDA amendment as unconstitutional, and what was left was Cox and Wyden's amendment, 47 U.S.C. Section 230. Ironically, when the legislative staff was preparing the House-Senate conference report on the final Telecommunications Act, they grouped both the CDA and the Cox-Wyden Amendment under the same title, Section 230 of the Communications Decency Act. You can still call it that. A lot of people still refer to it as Section 230 of the Communications Decency Act or CDA 230. I just refer to it as 47 U.S.C. 230. So before Section 230, there were two standard frameworks for intermediary liability law. We first had distributor liability. Now, distributor liability applied to your traditional, and still applies to your traditional print and broadcast media. Under distributory liability, if someone published something defamatory and the New York Times, for example, chose to run it in their print issue, the original author and the New York Times could be liable for defamation. This makes sense when you consider the level of control a publication like the New York Times has over disseminating the content to its general audience. On the other hand, we had common carrier liability, which was associated and still is associated with phone companies, mail carriers, and even, like railroad companies. Under the common carrier framework, it is unrealistic to hold the common carrier, like a phone company, liable for content transmitted by its users. For example, if I say something defamatory about you over the phone, there's no way that the phone company could, one, know about the transmission, and two, step in and prevent it. Hence, common carriers don't exhibit the same sort of control that distributors exhibit over content, and therefore can't be liable for it. Now, I'm just going to point out, this is sort of where you're hearing this platform publisher discussion. You may see it a lot. It comes up in a lot of Section 230 debate. This is really just an attempt for folks to try to place the internet into one of these liability frameworks, which is actually an incorrect way of framing the internet and thinking about the internet's liability. In fact, as you can probably imagine now, this put the internet in sort of a weird spot between both frameworks. So for example, internet services could act as distributors of content. This was common back in the early 90s when services like Prodigy, CompuServe, and AOL would curate and distribute their own paid-for content to their subscribers. But at the same time, internet services could also act like passive common carriers. This is the case for a lot of the user-generated content-based sites we use today, where content is disseminated immediately to the general public, usually without the service knowing about it or even controlling it. So which framework of liability does the internet fall into? Well, the answer is neither. Section 230 created an entirely new liability framework for internet companies that simply says, websites are not liable for third-party content. Essentially, for the United States internet companies, if I say something defamatory about you on a service like Twitter, for example, I'm still liable to you for defamation. But importantly, Twitter is not. But there's more. What many folks often forget about Section 230 is that users are not liable for third-party content either. This means when you share, retweet, comment on third-party content, Section 230 protects you from being held as the original author of that content. For example, if I post something defamatory on Facebook and you decide to share my post, the victim of the defamatory post cannot sue you for sharing the content with your friends and followers. And imagine if they could. Would you still be willing to share and retweet comment on social media? Section 230 is often credited with being the law that created the internet we know and love to hate today. Indeed, likely every single web app that you've interacted with just today alone relies on Section 230 in one way or another. Your email, chat, social media services, even web calendars are likely all US internet companies that relied on Section 230 to enter the market, get started, and now maintain their service. Section 230 provides for two key provisions under 230C1 and 230C2. Under 230C1, this is the one you really want to know, under 230C1, defendants must meet three prongs. The first is that the defendant is the provider or user of an interactive computer service. Now resist the urge to complicate it. A myriad of case law guarantees this prong applies to any website, service, software, platform, bulletin board, publisher, conduit, forum, on the internet, etc. The second prong is that the plaintiff is treating the defendant as a publisher or speaker. Courts interpret this prong broadly. In other words, the plaintiff is holding the defendant responsible in some capacity for the third-party content. The third prong is simply that the plaintiff's claim is based on information provided by another information content provider, aka third-party content. As long as the defendant, and usually its employees, did not author the content will be attributed to a third party. The reason Section 230 is often credited with creating the internet is because of the unique procedural values the law affords to internet companies, both large and small. Now, technically in the United States, the First Amendment's freedom of speech protection should cover a lot of the speech issues that regularly arise on the internet. For example, when it comes to defamation lawsuits, the First Amendment serves as a major hurdle for plaintiffs to get their speech complaints across. But it turns out that the First Amendment isn't actually that strong when compared to Section 230. In fact, when it comes to newly emerging internet companies, the First Amendment has a lot of vulnerabilities and weaknesses. For starters, Section 230 guarantees protection for all types of speech complaints. That simple little premise that websites are not liable for third-party content extends to all kinds of third-party content and speech. The First Amendment, though, has a lot of limitations and restrictions when it comes to commercial speech, for example. That leaves defendants with much uncertainty when it comes to defending under the First Amendment versus defending under Section 230. Additionally, over time, courts have interpreted Section 230 broadly to protect companies and users from all sorts of things beyond the traditional publication torts like defamation. For example, Section 230 has been interpreted to protect claims involving negligence, deceptive trade practices, unfair competition, false advertising, common law privacy torts, tortious interference with contract or business relations, intentional infliction of emotional distress, and more, whereas the First Amendment strictly applies to speech. Section 230 also grants internet companies peace of mind when it comes to resolving disputes early and painlessly. For example, Section 230 is usually pled as an affirmative defense before a case moves into an expensive and time-sinking discovery phase. That means cases are guaranteed to resolve quickly and cheaply under Section 230. The First Amendment does not grant those same guarantees. In fact, cases decided under the First Amendment almost always involve lengthy and expensive trials, an outcome that likely bankrupts smaller startup companies, regardless of whether they win or lose at the end. Lastly, Section 230 offers predictable outcomes for defendants, as well as a national standard. Section 230 specifically preempts state laws. This means that regardless of the state law, Section 230 is guaranteed to apply. This is especially important considering the US has several varying state laws when it comes to torts like defamation. For defendants, it doesn't matter what state they're sued in. The standard will be Section 230. The same can't be said for lawsuits under the First Amendment, which makes outcomes completely unpredictable. Predictability, standardization, and early dismissals are really important for emerging companies. Because Section 230 stands in the way, plaintiffs are less likely to risk suits against small businesses because they're almost guaranteed to lose. I would say almost always guaranteed to lose by that regard. Additionally, small internet companies that host user-generated content are more likely to push back and defend their users' speech because they know they're less likely to be sued. And even if they are, Section 230 guarantees them that win. Otherwise, small businesses might just be more inclined to remove content just to avoid the expensive legal risk. All of these benefits created by Section 230 help the internet become what it is today and continues to bolster innovation and competition. Because at the end of the day, while companies like Facebook, Google, and Twitter do rely on Section 230, they don't rely on it in quite the same way their smaller competitors do. To market entrants, Section 230 is a lifeline. Now, I did say there's a Section 230C2 part as well. So Section 230C2 provides 2 extra levels of protection to websites. Section 230C2A seemingly enshrines all content moderation decisions, protecting the quote-unquote good faith blocking of removal of objectionable content. Section 230C2B protects the blocking and filtering tools a website makes available to its users. So think about antivirus software or even ad blockers. Now, critics of Section 230 direct extra animus towards Section 230C2A, homing in on the provision's good faith prerequisite. Yet Section 230C2A is rarely ever tested in court. The good faith provision makes it expensive and time-consuming to litigate, which is especially harmful for market entrants with limited legal resources. In practice, the majority of Section 230 cases actually turn on 230C1, which is why I said previously, make sure you learn the C1 part. Even when the plaintiff's complaints are based on the service's content moderation decisions, they're still likely going to turn under 230C1. So this kind of brings us into the discussion of the Moderators Dilemma. So you might have heard of content moderation. Content moderation simply refers to the decisions websites make about content on their service. We call that editorial discretion. Importantly, we don't call that censorship, because censorship is what we call chilling speech when it comes from a government actor. And of course, internet companies like Facebook and Twitter and Google are not government actors. So again, content moderation refers to the decisions websites make about content on their service. The decisions to leave up content, take content down, to fact check content, all fall within the purview of a website's right to moderate their service as they see fit for their audiences. But it wasn't always this way, especially before Section 230. Throwing it back to 1995, a New York State court in Stratton-Oakmont v. Prodigy found the popular online service Prodigy liable for the defamatory material that was posted to their Money Talk bulletin board. In the interest of maintaining a family-friendly service, Prodigy regularly engaged in content moderation, attempting to screen and remove offensive content. You know, keep in mind, that's kind of what James Exxon wanted, right? But because Prodigy exercised editorial control, we're thinking about distributor liability here. They exercised editorial control, just like their print and broadcast counterparts. They were liable as publishers of the defamatory content. Now, the Prodigy decision came several years after a New York Federal District Court decision in Covey v. CompuServe actually dismissed a similar defamation suit against another web service, CompuServe, another popular competing online service from the 90s. Similar to Prodigy, CompuServe was sued for defamatory content that was published in a third-party newsletter, Rumorville. Unlike Prodigy, however, CompuServe employees did not engage in any moderation practices, such as pre-screening. So you can think of this sort of like the common carrier liability. The district court rewarded CompuServe's hands-off approach, holding that CompuServe could not be liable as a mere content distributor. This left online services with two choices: avoid legal liability, but at the cost of their users controlling the quality, or attempt to clean up the service, but with the understanding that these services would be liable for anything that slips through the cracks. This moderator's dilemma was what Section 230 was enacted to resolve. With that, Section 230 is sometimes described as a sword and shield. A sword for actively engaging in content moderation, like applying fact checks to the president's tweets, and a shield for protecting those moderation decisions. Some say internet services have no incentive to use the sword, but this is contrary to reality. Internet services rely on the sword to manage their reputation, to retain advertisers, and to maintain their competitive edge in the market. Failing to curb antisocial behavior is almost certainly a doomed business strategy, as anything goes services like Yik Yak found out the hard way. As a result, legitimate internet services routinely invest substantial resources in protecting users from harmful content. For example, Pinterest suppresses content that promotes eating disorders. Online gaming, geared towards children like Roblox and Fortnite, deploy proactive chat filtering software to screen abusive content before it's communicated. And importantly, especially today, sites like Twitter are using their editorial discretion to curb the harmful misinformation that spawns from our nation's own leaders. Content moderation is an incredibly difficult problem, mostly because it always creates winners and losers. The winners are happy with the outcome of the moderation decision, and the losers are not so much. Regardless, Section 230 protects all sorts of moderation decisions and activities, such as the pre-screening of content before it's published, correcting, editing, and removing content, as long as the edits don't substantially change the meaning of the original content. So this includes fact checks. Selecting content for publication. Here's an interesting part of Section 230. That means that the New York Times print version is liable for the articles it chooses to publish, while the New York Times website is not. Section 230 also covers the paying for content submissions by third parties and choosing to leave up content even when it violates terms of service agreements. Importantly, there are a few things outside the scope of Section 230. Section 230 does not apply when a website materially contributes to the violation of federal criminal law. Section 230 does not extend to violations of the Electronic Communications Privacy Act. It doesn't cover federal intellectual property infringement. However, websites can take advantage of the Digital Millennium Copyright Act, Section 512 Safe Harbor for IP claims. Lastly, as per a recent amendment via the 2018 FOSTA-SESTA law, Section 230 does not extend to sex trafficking issues. However, this does remain fairly new and uncharted territory of Section 230. And I actually don't think to this date we've actually seen any FOSTA-SESTA civil cases implicating 230 yet. So stay tuned. There are a few other instances in which Section 230 will not apply. Editing content that materially alters the meaning, and failing to comply with promises to remove material under a promissory estoppel theory. Now, keep in mind, this is a little tricky because I said earlier, the terms of service, just not taking content down that you say violates the terms of service, that is protected by Section 230. That's a little bit different than this last part, the promissory estoppel theory, where a website will, if a website goes out of their way to tell a user that they will take down content and then they don't take it down, Section 230 usually doesn't extend to those promises. Without Section 230, the types of content we interact with on a regular basis on these services could not exist in the way that they do today. Countries without Section 230 often experience what we call the splinter net effect, where free expression is chilled by geofencing and government censorship. Unfortunately, though, Section 230 is under attack from both sides of the political aisle in the US. Both President Donald Trump and former Vice President Joe Biden have called for a full-scale revocation of Section 230. The left typically believes that internet companies are not doing enough to curb online harms such as misinformation, sex trafficking, child exploitation, and non-consensual pornography. The right believes that internet companies use Section 230 as a means to chill speech. With that, it's unsurprising that we're seeing several proposals bent on amending or all out destroying Section 230, such as Senator Graham's Earn It Act, which eliminates Section 230 protection for child sexual abuse materials. Senator Hawley's limiting Section 230 to Good Samaritans Act, which would require websites to promise to operate websites in quote unquote good faith in exchange for 230. And Senator Thune and Schatz's PACT Act, which requires websites to respond to complaints about potentially policy violating content in 14 days and court orders regarding illegal content or activity within 24 hours. Each of these bills have some flavor of tech lash or tech panic. Put bluntly, regulators just don't understand the internet. At least United States regulators do not. Hence, they don't understand the challenges we face every single day. People who work in trust and safety, the types of content that we encounter, every single day. So some regulators probably think that most content comes with a giant neon sign that says, this is illegal content, delete me. And obviously it doesn't. At least that's what's reflected in a lot of these proposals. But the theme is always the same and the message is clear. Congress doesn't feel the same way about the internet as they did in 1996, and Section 230's days are numbered. So with that, I will conclude the overview of Section 230. I'll go ahead and stop sharing my screen and we can kind of take this conversation really anywhere. Neil and I have some questions, or I would love to hear from the audience as well.
Yes, that was fantastic. Thank you for talking us through that. Although the focus has very much been on the US law in this area, it's completely pertinent to activities that are going on both at European level in terms of terrorist content moderation or removal proposals, and in particular, challenges that we're seeing in the UK at the moment. I thought the idea that Section 230 protects users as well as platforms is a particularly interesting notion. And I think you made the comment that, would you be willing to share or retweet if you could be liable for the defamation in respect to the content that you've retweeted? That's not a protection that exists at European level. Our intermediary liability laws protect only intermediaries. They don't protect users. So I wonder whether we don't have a protection that you already have. But looking at the challenges to Section 230 at the moment, or the proposals for amendment, what do you think the future of Section 230 is? And if, as you say, Section 230 is critical to the evolution or the development, at least, of the internet, what do you think the future is for the internet?
Yeah, it's a great question. It's somewhat of a depressing question too, when you are someone so passionate about Section 230. I think the future for Section 230 is grim. There are a lot of proposals right now out there aiming to do something about Section 230. It's very clear that regulators don't know what they want to do about Section 230 because every single proposal is different. But I do think we're going to reach a tipping point where, it's bipartisan hatred. It's on both sides. As I mentioned in the presentation, both sides have have fallen out of love with Section 230. So I will be surprised if we get through the end of this year without some sort of substantial change to Section 230. The Earn It Act particularly is problematic. Senator Graham is trying to hotline it through right now. But I do think the future is grim. Maybe I'm just cynical. As far as the future of the internet goes, I think it depends. Speaking like a law student, it depends. It depends on what actually gets amended into 230, because there, again, like I said, there's a lot of proposals out there. So something like the Earn It Act, I said I was concerned about it because it is an amendment to 230. It's slowly becoming toothless in that regard. Section 230 doesn't protect websites that facilitate child pornography or that actively help to facilitate child pornography. And this Earn It Act would go forward and say that websites have to basically do more about child sexual exploitation material to receive Section 230. And so, for that for websites that are already combating CSAM, I wonder how effective Earn It or how impactful Earn It will be. Now, this is, when I say impactful, I'm talking about the big internet companies, right? I'm talking about Google, Facebook, Amazon. Those companies will be okay. And they'll be very okay if we amend Section 230. And I know a lot of, if you work for those companies, you probably don't want to hear that. But the reality is that those companies have the money, they have the resources, they can handle if something horrible happens to Section 230. The real bummer, like the one thing that I worry about the future of the internet is we all talk about how badly we want to break up big tech and we want to see competing services. And the more we Swiss cheese Section 230, or if we all out repeal, revoke it, I can tell you that we're not going to see as much competition. Those competitors are not going to want to risk the substantial business liability that comes with hosting user-generated content. So maybe, we could go back to the cableized version of the internet that, I saw you clarified AOL or like CompuServe Prodigy, because those websites at least could have full control over what's disseminated to their users. That'd be a pretty boring internet, in my opinion. Like, imagine an internet without user-generated content. I think about sites like Omegle too. I don't know if anyone has ever used omegle.com. It's actually making a resurgence because of the COVID-19 quarantine era, but Omegle's got less than 10 employees. They are desperately relying on their Section 230 protection so that they don't get sued for something that one stranger says to another stranger online. Without Section 230, I don't think sites like Omegle could exist. And I think that's depressing. That's a bummer. It means that our internet kind of ends up Google.
If you only make laws that large companies can comply with, all you will end up with is those large companies. And those large companies tend to be the incumbents.
Absolutely.
Not a pretty picture for the future. We have a question from the audience. Are there exceptions? Are the exceptions to Section 230 actively policed? How many instances are there of successful actions against internet providers?
Yeah, so I don't know the exact specific number. There's plenty, and so are they actively policed? Yes. So let's talk about the federal criminal law exception. I think that one is particularly important. I'm going to go back to the Backpage case. I don't know if people are familiar, but Backpage, it was a site that was, I'm just going to put out there, it was somewhat shady. It promoted legitimate sex work, which, I am pro-feminist, I am pro-legitimate sex work, but it also may have had some underhanded, help and creation with sex trafficking. And so, the sex trafficking of children, just illegitimate sex work. The FOSTA-SESTA bill came out of this decision to target websites like Backpage. But the interesting thing about it is that Backpage came down and the DOJ prosecuted Backpage and Backpage's creators before FOSTA was even signed into law. So that was an instance where a lot of people were saying Section 230 is causing this illegal, it's allowing websites to get away with sex trafficking children, etc. And at the end of the day, the DOJ, nothing stopped the DOJ from prosecuting and taking down this service. That happens regularly. Section 230 doesn't stand in the way of, FTC actions. It doesn't really stand in the way of the DOJ. So a lot of these, again, in the case where I personally believe Backpage probably needed to go, Section 230 doesn't hinder that. And importantly, you asked your question asked who's policing those exceptions to Section 230? And I'm going to stay on the federal criminal because, again, intellectual property is it's well suited that we have the DMCA. The ECPA, we rarely see those kinds of issues. So we're really talking about federal criminal law. Enforcement is really it's self-policed, right? Because one, these websites don't want to set themselves up for DOJ prosecution and for liability, but two, we have to remember that these websites, especially ones that operate for free and rely on advertisers, they don't want to have their content associated with federal crime, especially when it comes to stuff like child pornography. I mean, Facebook and Twitter and Google, they'd be devastated if they didn't do anything about, something so horrific. So a lot of it, yes, we do have the DOJ that can prosecute these horrible things, but a lot of it, the whole point of Section 230 was that these websites would be good Samaritans and they would self-police. And we do see that regularly. We could talk about revenge pornography, for example. I think revenge pornography is actually super interesting. We don't have a federal law in the United States that targets revenge porn. We have some state laws, but Section 230 doesn't apply to state laws, right? Well, even though we don't have a federal law for revenge porn, the Section 230 exception doesn't kick in. These major websites do a lot to combat revenge pornography at the very beginning. So much so where, they're writing algorithms that predetermine or pre-detect revenge pornography that comes in and takes it down before it's even disseminated. And to me, that's, yes, it's important for the victim to get relief, but it's important for the victim to not become a victim in the first place.
Oh, interesting. We have a follow-up question, which I think goes into your moderation side of things. And the question says, as Section 230 does not provide procedural or substantive guidance on how platforms ought to moderate content, do you think this gap is adequately filled by voluntary regulation?
So this is a good question. I think it's important to think about first, what exactly is the objective? So what would the voluntary regulation actually fulfill? And so this is a common issue that keeps coming up in the United States government, where they keep proposing these different bills to amend Section 230 because they don't know what it is that they want from these services, right? So let's take a case study. Let's take COVID-19 misinformation and disinformation, because that's relevant right now. What would the voluntary regulation be? Okay, so what do we want? What's the objective? We want websites to curb misinformation, disinformation about COVID-19 material. Okay, so you write a voluntary regulation that says that websites are, they're liable if they don't do anything about the misinformation, disinformation of COVID-19 content. The reality of that is that, like, how will that be applied, right? So first of all, this kind of gets into the whole content moderation is super difficult. So we need to leave it up to the services to define how they want to handle terrible content. So we have a problem in the United States, as many of you are probably aware, that a lot of the misinformation and disinformation about COVID-19 actually comes from our government leaders themselves. So what's the decision to be made here? Should websites, because now they are held liable for COVID-19 content, remove content that's coming from official government sources? And how are they able to be sure that that government source that they're removing the content from is actually telling the truth, or is actually an expert? Like how do we've got Dr. Fauci, how do we, compare content that he says, to content coming from someone else? These are really, really difficult decisions to make. And so at the end of the day, you've put this liability, you've made this voluntary regulation. What was the objective? What was achieved? Well, likely, the goal in mind was good. Let's get rid of COVID-19 mis and disinformation. But it doesn't solve the underlying problem, which is that we don't know what is misinformation or disinformation in the first place. So we don't know what we're removing. And when I say we, I don't mean Google. I'm talking about like just in general content moderation. So at the end of the day, this regulation comes in, and you're probably either going to still have services that are hosting bad COVID-19 information, or you're going to have the flip side, which is for services that are not the big tech companies, they're just going to say, listen, you can't host anything that talks about COVID-19. Maybe that's a good thing, like that's a different conversation we can have. Maybe that is a good thing. Or maybe we want services to be able to host information about COVID-19 because this is the internet and we want to have free-flowing information. So it's sort of a decision that we have to make. But at the end of the day, when we're talking about voluntary regulation and we're talking about guiding social media services or internet companies to moderate the internet, we really need to think about what's the objective and will that regulation get us to that objective? Likely the answer is no.
And I think that plays nicely into another question which we've been asked. It sounds as if there is no legal obligation that would require a social media company to do fact checking. In other words, is there, from a US federal point of view, an obligation on platforms to check that what users are posting to their services, to check that what they're posting is correct?
Yeah, absolutely not. And that gets back into my note that I made in the presentation. So we have, we've got the First Amendment, and you hear this a lot. Internet companies are censoring speech, right? Internet companies can't censor speech because governments censor speech. Government actors censor speech. Now I know, there's the legal way of using the word, and there's, kind of the colloquial way of using the word. But when we're talking about the law, government actors censor speech. When we're talking about newspapers or internet companies, they apply their editorial discretion to the type of content that they want to carry. If they were required to fact check users by the government, that would be a huge violation of the company's First Amendment rights to decide what kind of speech they want to carry. But it's not a violation of our First Amendment rights, because services like Twitter don't owe us US citizens. They don't owe us our free speech rights. They're not government actors, right? So there isn't a legal obligation. You're correct. There isn't a legal obligation that would require Twitter to do fact checking. And we know this because Facebook has actually come out and said that we don't do fact checking. I think there's a moral obligation, though. I think there's a societal obligation. There's a responsibility for these services to fact check and to help, kind of provide appropriate or educational information to these users, especially major services that carry the speech of government officials.
Question on a slightly different screen if you're following online. Has Jess been following the proposals in the UK about the online harms white paper, in a sense, establishing a duty of care that platforms must protect users from the actions of other users? And if you have, do you have any comments or thoughts on the likely impact?
Yeah, so I have followed it, kind of a cursor. I'm aware of it. I've cursoried, done a cursory review of it long time ago. Professor Eric Goldman actually has a more extensive paper out there where he actually goes through and, enumerates every piece of the online harms paper, and then, gives his thoughts on it. My thoughts on the duty of care principle in general. So again, it goes back to what I said about the voluntary regulation. What if we don't change the underlying problem, right? And so the underlying problem, in my opinion, is society. Society is going to continue putting out terrible content. Now all you've done is you have made it harder, or you have strapped this liability to internet companies to have to, crack down or quote unquote nerd harder to police this awful content in order to protect their users. But the thing is that if you look at these, let's just focus on the major companies again. If you look at the major companies, maybe Facebook aside, most of these companies are already working. They already have this intrinsic duty and responsibility to their advertisers and to their users to protect them from online harms. They're already working at full capacity, full resources to be able to, innovate on content moderation and to improve their services. So I question if hitting them with this duty of care or hitting them with this extra liability to protect users, if the innovation, the technology isn't there yet, and we don't have any way of stopping people from posting horrible content on the internet, I wonder if we're really going to achieve the objectives that, the UK online harms paper hopes for the internet.
I don't think you're the only one that shares the view that what the government is trying, or what the proponents of this legislation are trying to achieve, know exactly what they're trying to achieve, yet alone the second bit, which is whether it's going to get there. We've had a request in the comments. Can we have a link, please, to Eric Goldman's paper? You're ahead of me on that. We can certainly make that available. We'll probably tweet about the webinar when the recording becomes available, and when we post it on the SCL website, we'll try and include a link to that blog post.
I am grabbing it right now too. There you go.
There we go. I think we shall wrap it up at that point. Thank you for the most fascinating overview of the US situation, for taking so many questions and expanding on the points that you've made. We really appreciate you taking the time, especially so bright and early on a Thursday morning for you. Thank you for joining us today, Jess.
Absolutely, and thank you so much for having me. And again, thank you to all of you that tuned in and for your awesome questions as well. I really appreciate having the conversation. And if you follow me on Twitter, again, warning, that's all I talk about. So follow me at your own risk.
At Jess_Miers. Wonderful.
Thank you all.
Thank you all for joining as well. Thank you for your questions, and look forward to seeing you at other SCL events very soon. Have a good evening.